My name is Michael Young, and I'm a lawyer who handles life insurance beneficiary disputes. And in this video, I want to talk real quickly about what happens if you're the designated beneficiary of a life insurance policy and you receive notice from the insurance company that they're not going to pay you, at least not yet, because somebody has contested the beneficiary designation in your favor. In that situation, it's understandable that you would be upset and be asking questions about why you're not being paid if the insurance company has acknowledged, at least potentially, that you are the designated rightful beneficiary. So let's talk about that for a couple of minutes. So why has the beneficiary designation been challenged? Well, there are a number of grounds for that. There could be technical issues with the designation that has concerned the insurance company, but more likely somebody has obtained a lawyer and has written a letter to the insurance company contesting the beneficiary designation in your favor. Now, one thing you could do is to simply haul off and send a letter or an email to the insurance company being very upset and lodging all kinds of accusations and demanding to be paid, or you're going to sue the insurance company. That's one way to do it, but it's not the best way to do it, because at that point, you really don't have a great idea typically of what the contest is and what your legal grounds are. The best thing to do is to step back, pause, call a lawyer who is experienced in handling life insurance beneficiary disputes, and review with the lawyer what the steps should be, because typically the best thing to do is not to haul off and write angry letters or emails to the insurance company until you can obtain more information. In that situation, when I'm consulted, one of the first things I'll do is to call or follow up with a letter to the insurance company asking for an explanation. What is the basis of the contest? And who is it that has filed a competing claim to the life insurance proceeds? What's the basis for the contest? And what's the insurance company's position if they have one? Typically, what they'll say up front is that the matter is under investigation. Now, almost every time I represent a designated beneficiary, the question is, Mike, can we convince the insurance company simply to pay me and not move forward to an interpleader? And an interpleader is where the life insurance company goes to court and tells a judge, look, we have competing claims to the policy proceeds. We're not sure who to pay. So in order to protect us, the life insurance company, from potential double liability, judge, we want you to decide, or we want a jury to decide. Almost every time the insurance company is going to take that path. But that's where it's very important to consult the lawyer. If the challenges are of a legal nature, and if we can show the insurance company that those legal challenges are baseless, they may attempt to reach out to the other side and convince them that that is indeed the case. And there's the potential for you as a designated beneficiary, with help from a good lawyer, to receive payment. However, it's much less likely if the challenge is based on something very fact-intensive, such as an allegation that the designated, the owner of the policy lacked testamentary capacity or contractual capacity to execute the designation, or that there was undue influence involved, or that there are some state laws that may overturn the designation. It really depends on what the grounds are for the dispute in order to evaluate whether or not there's the potential to convince the insurance company simply to pay you as the designated beneficiary instead of going to court to file an interpleader. In either case, it really is very important that you contact a life insurance lawyer up front to get some good help and some good guidance, because sometimes by the time people come to me, the interpleader has already been filed. And that's not really a problem unless I look and see that the person has angrily fired off a letter to the insurance company, and maybe their brother-in-law or their wife helped write a letter, or maybe their buddy who does criminal or personal injury law has written a letter to the insurance company, and maybe they didn't have all the facts before they did that, and that's not really in a good position to be in. It's most important to gather the facts, learn why the insurance company is concerned about a contest, and then react from there appropriately and set up the best case possible to claim the life insurance proceeds if the insurance company does go to court and file the interpleader.